All right, getting in details as far as the order against, in fact, order in this case is concerned. High Court has said Arvind Kejriwal conspired with others. Remember, the court is deciding on whether Arvind Kejriwal deserves immunity from protection or not. Judge, I beg your pardon, Judge Swarna Kanta Sharma right now pronouncing the verdict on the Delhi Chief Minister. High Court, in fact, has also said that the Chief Minister conspired with others and he was allegedly involved in two capacities, in personal capacity in formulation of policy and collecting kickbacks, and also as the national convener, the top boss of the Aam Aadmi Party, says Judge Swarna Kanta right now. In fact, talking about how material collected, in fact, indicates that Arvind Kejriwal conspired with others and was involved in taking kickbacks and generating proceeds of crime in personal capacity, in formulation of policy and collecting kickbacks in two capacities essentially. And the second capacity as the top boss of the Aam Aadmi Party. He, remember, is the national convener of the Aam Aadmi Party. Nalini, in fact, continues to be with us. We'll also try and get in a sense from Shreya in a moment from now. But Nalini, like we were saying, we are just waiting for the court to, in fact, give an idea. But right now, the court has also spoken about the fact that in two capacities, essentially, was Arvind Kejriwal's role. And it's worth looking at it very closely, given that he's also the top boss of the Aam Aadmi Party, and that as the head of the government here, he was in a position to get kickbacks and to decide on policy matters.
Well, absolutely. And Sneha, this was a case that even the ED had made out during the arguments before the High Court, saying that the Aam Aadmi Party was directly involved in this entire matter because Arvind Kejriwal was the national convener of the Aam Aadmi Party. And if Arvind Kejriwal is the kingpin and the key conspirator, he was in the complete know-how of exactly what was happening regarding the excise policy. The ED had also said that, of course, he wasn't handling all of the money himself, but that does not mean that he wasn't aware of exactly the kickbacks that were happening related to the Aam Aadmi Party in the Delhi excise policy case. Right now, what the High Court is saying is that the Arvind Kejriwal was in this entire case involved in two capacities. Number one, he was involved in his personal capacity in the formulation of the policy and collecting the kickbacks. And second, he was also involved as the national convener of the Aam Aadmi Party in the entire case.
That's right.
The High Court is also saying that Singhvi had questioned the statements of the approvers and said the statements are unreliable. The High Court says that statements by Raghav Magunta and Sharath Reddy are statements of approvers which are being termed as unreliable by Abhishek Manu Singhvi on behalf of the Delhi CM Arvind Kejriwal. And High Court says that the statements, all of these statements that were being relied on by the ED were in fact recorded before the court itself. So doubt and aspersions on the manner of granting pardon or taking statements amounts to casting aspersions on the process itself. Statements of approvers are not taken by the ED. It's a judicial process where statement is recorded under the CRPC. Yes. So the High Court has made it very clear that it is not going to accept the argument that was being made by Arvind Kejriwal that the statements by the approvers were unreliable, because the court has said that all of these statements were recorded before a court of law, and questioning the statements means questioning the process itself, questioning the court itself. They're clearly stating that casting aspersions on the manner of recording the statements is equivalent to casting aspersions on the judge that recorded these statements. The High Court's also gone ahead and said that bail is a judicial prerogative and not the prerogative of that of ED, right. Which means that ED is not in the capacity to decide as to whether or not somebody should be allowed out on bail. That is ultimately the decision of the court. But a big statement coming in from the High Court at this point is that the statements can in fact be relied on. The statements that have been made by the approvers can be relied on, because these are not just statements that the ED has taken. These are statements that have been recorded in the presence of a judge before a court of law, and casting any aspersions on these statements itself is equivalent to casting aspersions not only on the process but also on the judge who has recorded these statements.
That's right.
Shrishti is getting us more updates where she says that the High Court is saying that questioning statements of approvers and grant of pardon will be like questioning the judicial process, which is governed by the law and not by the agencies. So a very stark distinction that is being made by the High Court between what the powers of the ED are versus what happens before a court of law, because there has to be some sanctity given to the judicial process and the process of rule of law, where there are statements that are being recorded before a concerned judge of the trial court. The High Court says that the law of the approver is more than 100 years old. It has been tested by the Privy Council right up till the Supreme Court, and the law regarding approvers is a law that has not been struck down. The High Court says this is not the first case where approver statements have been relied on and trials have happened.
It's an important point that has been made by the court. I'm also going to be bringing in my colleague, Shreya, who continues to be with us. Shrishti, remember, is inside court getting us the details. Amit too is with us for the very latest on that. Shreya, I'm going to come to you on that point where Nalini left off, essentially was where the court essentially is saying that do not question this. The trials in the past have also been conducted relying on statements made by approvers, so that isn't something that should be questioned.
Well, you know, Sneha, these observations coming in from the High Court, we can read it as a setback for the Aam Aadmi Party. As my colleague Nalini was reading them out, remember the Aam Aadmi Party has been harping again and again that the approver, and mainly Sarath Chandra Reddy, connecting his donations to the electoral bonds that got routed to the BJP. Again and again, the Aam Aadmi Party was casting aspersions on the approver statement. Now, the High Court has very categorically said that these statements are in judicial process. When you're questioning the statements of the approvers, you're somewhere down the line casting aspersions on the judiciary, the judicial process. They've also gone ahead to said that the Supreme Court has not struck down the approver statements. This case is not the first time where approver statements have been relied on. Trials have happened where approver statements have been relied on before as well. So clearly we can read this as a setback for the Aam Aadmi Party. Also for our viewers, I want to remind that the Enforcement Directorate earlier in the Rouse Avenue court had also made the similar argument that the reason for the change of statement of the accused who turned approvers were also well documented and submitted before the High Court. That's exactly the procedure the High Court is now explaining.
That's right. We are discussing the details of what really is expected today as far as the High Court is as far as the High Court pronouncing the order is concerned. They've given in details as to how Arvind Kejriwal, in fact, can be questioned in two capacities here. It's an important statement that has been made by the court, and I'm just going to reiterate that in a moment. He was allegedly involved in two capacities, in personal capacity in the formulation of policy, collecting kickbacks as the national convener of the Aam Aadmi Party as well as a top boss of the Aam Aadmi Party. We'll just go back to the developments in the court in a moment from now. Amit Bhardwaj also is getting us more details. Amit, in fact, the AAP has said that whatever the case is, we are going to, in fact, plan on our next strategy. Okay, we'll go back to Amit in a second from now. Getting in details from what the court essentially is saying. And once again, Nalini continues to be with us. Nalini, the court has said in two capacities, essentially, his role has to be looked at. One is that he is the national boss, the national convener, top boss of the AAP, and second, that he was in a position to receive kickbacks and formulate policies, and that is why his role is under the scanner.
Absolutely, Sneha, and some very important observations coming in from the High Court as part of the judgment, where the High Court is saying that at this stage, at the stage of where the arrest is being questioned, the court cannot be given the authority of conducting a mini trial. The High Court cannot step into the shoes of the trial court and conduct a mini trial at this case, which is why they're saying as to whether or not these statements are credible is something that can be examined at the stage of the trial. They're saying that Arvind Kejriwal and his lawyers will be given a chance during the trial to cross-examine all of these approvers, alleged approvers, and they can question them on their statements and ask them why these statements were changed, why they hadn't taken Kejriwal's names earlier. So the High Court has categorically said that at this stage, they will not conduct a mini trial and get into these aspects. The High Court very importantly has also said, because there were arguments that were made by Kejriwal's lawyers alleging issues related to the grant of tickets for the elections, how certain people were given tickets in lieu of their statements, how there were electoral bond donations that were made by these same persons who have now turned approvers. But the High Court has categorically said that who gives tickets to who and who purchases bonds is not the concern of this court. That is not an issue that is before this court. The court simply has to decide on Arvind Kejriwal's role in the excise policy case and as to whether or not his arrest was legal.